The Supreme Court's new decision tilting the midterms towards Republicans explained. The court's new gerrymandering decision is tough to explain unless you think the justices are GOP partisans, which, spoiler alert, they are. They definitely are. They really are. It's a classic Republican trope to project onto liberals and the left as a boogeyman exactly what you're doing, right? And they are the definition of activist judges. On Tuesday night, the Supreme Court handed down a decision that will almost certainly give the Republican Party an additional seat in the U.S. House of Representatives. Not all of the justices disclosed how they voted, but the decision appears to have come down 6-3 along partisan lines. That is, the 6 Republican justices voted to give the GOP another House seat, while the court's 3 Democrats dissented. In fairness, the GOP justices' most recent decision in Allen v. Milligan fits a broader pattern in the Supreme Court's gerrymandering cases that can be explained without accusing those Republican justices of deciding election cases solely on the basis of partisanship. The court has spent the past 7 years dismantling all federal safeguards against gerrymandering. It was Texas about a year ago in 2025 that really opened the floodgates for all of this, right? Trump came out and explicitly, like with fully mask dropped, like normally they try and like hide the ball a little bit more than this, but he just came out and said, hey, Texas legislature, redraw your maps, engage in redistricting, and find us 5 more seats in the U.S. House of Representatives, right? I'm sure because he probably predicted, and probably correctly so, that Republican polling for the next midterms weren't going to be good and that they probably weren't going to perform very well. So this is probably some way to try and like mitigate the damage and potentially hold on to control of the House of Representatives, right? Because right now, Republicans have control of the House of Representatives, the Senate, and the presidency. So they can successfully pass any legislation that they get all of the Republicans on board with. While if the House of Representatives falls to the Democrats, which is probably the most likely of the 3 to do so in 2026 during the midterms, then they will lose the ability to pass Republican-led legislation, and Trump will become a lame duck for his last 2 years in office. For reference, typically congressional redistricting happens every 10 years, right? It happens with the census, right? You use the census data to do redistricting, right? And sometimes House seats are completely taken away from certain states and given to others, right? Because House seats are supposed to be, and they are allotted to the states based on a proportional amount of citizenry in those states, right? There's 435 House members, and the House of Representatives has not been expanded since like the 1930s. The founders of this country, right, the writers of the Constitution, intended for the House of Representatives to continually be expanded so long as the population of the country was expanding, right? It's supposed to be a roughly proportional amount of people, amount of citizenry, amount of population per House seat. And so that's why a state like Texas has far more House of Representative seats than a state like Maine or Alaska or something, which might only have 1 or 2. We haven't expanded it since like the 1930s, but the population of the United States has, like, I'm pretty sure more than doubled since then. So that means that like your vote now means like a half or less than half of what it meant like back in the 1930s or before, because there were far less people per representative. Your vote went further. And right now, if Congress did their job and continued to expand the House of Representatives proportionally, along with the growing population over the last however many decades, over the last 100 years, it would probably be over something like 600 House members, right? Which is what it should be, but it's been stuck at 435. The Republicans would never agree to that because they understand that it helps them electorally far more than it helps the Democrats. In the exact same way that the Senate is like structured, favors conservative interests, favors the Republicans far more than it favors the Democrats. The Senate gets 2 flat senators per state, regardless of the population of the state, right? A state like Texas, Florida, or California, or New York or something, those states that have like humongous populations that make up a huge portion of the country's overall population, get the exact same number of senators as a state like Maine or Alaska or New Hampshire or something, which have a far, far, far smaller population. That inherently helps Republican, more rural-based conservative interests far more than it does the Democrats. And this was set up originally sort of on purpose, right? It was intended that the Senate be the body of government, the body of Congress that like sort of leans more towards like rural interests, right? It was structured that way so that the urban city centers that have much higher populations couldn't just steamroll the interests of those in more rural areas. which sort of makes sense, right? You want there to be a fair amount of representation. You want the rural interests, which tend to lean more conservative, be represented as well. The political conditions and material conditions and reasoning behind the types of people that live in inner city New York might be different than the types of people who live out in the middle of nowhere, Kentucky or something, right? So you want them both to be able to be their interests to be properly represented in government, but that's supposed to be through the Senate, right? Not the House of Representatives. And so the longer we go, the more the population of the U.S. increases. At the same time, we don't increase the number of seats in the House of Representatives, the closer it becomes to what the Senate is doing, right? The more and more it favors these rural conservative interests. Typically, these House district redrawings, which is like basically the map that shows like, okay, if you vote in this area, it goes towards this specific House member seat. That redrawing happens every 10 years along with the census data. Well, Texas came out and was like, nope, we're just going to do it at the 5-year mark because we want to, because we want to get these partisans, we want to get as many seats as we can. We want to gerrymander. And this 2026 election could be important. And then a whole bunch of other conservative states follow suit, right? There's Alabama, there's Louisiana. I can list some more on the screen that aren't coming off the top of my head right now. And I know even some of the Democratic states have counteracted this. Most of the Democratic states are taking the high road, right? They're saying, oh, this is wrong. You shouldn't morally. It's against the good faith nature of the government and government and governance, and you shouldn't engage in this gerrymandering. Oh, how dare you? We would never do such a thing, right? Which, is all high and mighty and good for you, right? But it doesn't mean anything. Like if all of the conservative states come together and all gerrymander multiple seats per state, right? And all of the Democratic states just pretend like they're taking the high road and they're the morally righteous ones, right? Well, what does that buy you? Like a soda at the grocery store? Right? That doesn't mean anything, right? This is far too high stakes of a game to be playing, to be doing that kind of thing, right? It's sort of the same kind of thinking that probably got the whole Democratic establishment behind Hillary Clinton, specifically in 2016, right? That she had, been in the system for a long time. She had sort of worked her way up in the ranks of Democratic leadership, and that it was her turn, that she was next in line, right? They didn't look so much at who would be the best candidate, but more so like, well, she's the next one in line, basically. And it's just too high stakes of a game to be using that kind of thinking, right? This isn't Little League baseball. This is control over the government of the United States of America, the most powerful, influential, and important government in the entire country, in the entire world. So you can't be playing, you can't be using Little League fairness rules when it comes to the United States government. It doesn't make sense. But yeah, some of the Democratic legislatures have come together and said, hey, we're recognizing that these conservative states are engaging in bad faith partisan gerrymandering, and that we're either going to engage in our own or we're going to write bills that are conditionally gerrymandering our districts based on that. So basically what they'll do is they'll redraw their maps to say, hey, here's a redrawn, gerrymandered, in our favor, Democratic map that we could institute here. And this bill we're going to write, it says, okay, if Texas goes ahead and passes their partisan gerrymandered map, this one will take effect, but otherwise it's not going to take effect and we'll keep our old one. And to me, this seems like the best of both worlds, right? It allows you to maintain some level of moral, righteous high ground, right? It allows you to sort of take the high road, but also to counteract the rank partisan power grab that these Republican conservative states are engaging with. It allows you to some way to counter it, right? Because like I said, it's no good for all the Democratic states to take the high road at the same time that a whole bunch of the conservative states, Republican states, are going ahead with this partisan gerrymandering, right? It's just too high stakes of a game to let them do that with no recourse, right? Obviously, like the nicest solution to this would be Congress passing some sort of bill, saying, hey, here's a way to quantify partisan gerrymandering, and you're not allowed to cross that threshold when you do gerrymandering and yada yada blah blah blah. But like, there's no shot that they're going to do that. Right? Probably mostly because of the Republicans, right? They probably realize that like their ability and willingness to go ahead with that sort of thing is much higher than the Democrats. My understanding and my vibe is that Republican voters are far less informed about that sort of thing, and they care far less than like Democratic voters. And so they probably realize that the penchant for that sort of thing on the Republican side is far higher than the Democratic side, and it will be for the foreseeable future. And so, They see that the system, the way it is, benefits them more than the Democrats, and that they have no incentive to change it. So I don't have any faith or any hope, really, that that kind of thing would ever get passed. Allen fits this pattern. On its face, the Republican justice's brief opinion on the case is just the next iterative step towards a legal regime where states can draw maps however they want, regardless of whether those maps are drawn to favor one political party or whether they are drawn to lock non-white voters out of power. But the Republican justice's new decision stands out because while the Allen opinion is consistent with the court's broader trend towards redistricting anarchy, its actual legal arguments are inconsistent with things the same justices said as recently as 1 month ago. The decision is also inconsistent with previous orders that the court's Republican majority handed down in the Allen case itself. If you want the full rundown of all of these inconsistencies, go read Justice Sonia Sotomayor's dissent in this most recent decision. There are so many of them that it is hard to escape the conclusion that the court's Republicans aren't being honest about their true motivations. The simplest explanation for Tuesday night's decision is that the court's Republican majority is bending the rules because they want the Republican Party to hold a majority in the House. Yeah, that shouldn't be surprising at all, right? Like I said before, it is a classic Republican trope, especially in the legal realm, for them to project onto like a liberal boogeyman exactly what they're doing, right? That they are activist judges and that they are politicizing the courts. The way the Supreme Court is set up, the way our legal system is set up, it's supposed to be apolitical, right? They're supposed to be beholden to legal standards, to the rule of law, and not so much if a decision benefits a Republican or Democrat. Politics is in theory not supposed to be involved in that process, but arguably because of the inherently political way that Supreme Court justices are appointed, you could argue that even since the conception of this country, even since the conception of the Constitution, that the system there, this notion of the courts being apolitical, being only legal entities strictly, is kind of a fantasy. But this has really been kicked into gear over the last 10, 15, 20 years, right? And especially so since the 3 Supreme Court justice appointments he got during his first term, right? Who appear to be extremely partisan. You could argue one of the big moments for this was also the 2000 election between George Bush and Al Gore. It came down to a district in Florida needing to recount all of their votes. And the Supreme Court basically came out and was like, no, you can't recount them. We're going to exit out. And where the count stands now is where the count stands now, which was favoring Bush, and that he just wins. The decision in Allen breaks a rule that the Supreme Court announced 1 month ago. At the end of April, the court's Republican majority handed down Louisiana v. Calais, which completed a project that at least one member of the majority began more than 4 decades ago. In 1982, President Ronald Reagan signed legislation expanding the Voting Rights Act, the federal law barring race discrimination in elections. Among other things, the 1982 amendment established that many state election laws that have a negative impact on non-white voters are illegal, even if the plaintiff challenging that court cannot prove that the law was enacted with racist intent. Yeah, it's sort of like an acknowledgement that if a state is engaging in racial-based redistricting, if they're trying to redraw the districts so that certain races are favored or disfavored over another, that they likely would not come out and openly admit it, that's exactly that's the reasoning they're going behind it. So this is saying, regardless of what you are saying your intent is with this redistricting, it's the effect of it that matters, which makes the most sense, right? That's the only thing that matters. When this bill was being debated in Congress, however, there was a conservative faction within the Reagan administration that opposed it, and which unsuccessfully urged Reagan to veto it. Future Chief Justice John Roberts was a member of this faction, and as a fairly junior lawyer, wound up doing much of the granular work that is often assigned to young attorneys. Among other things, Robert wrote about 24 memos opposing the 1982 amendment, and he drafted speeches and talking points for senior lawyers who opposed it. Although Roberts' faction failed in 1982, Roberts held onto his grudge against the Reagan administration to the VRA, and his faction eventually took over the Republican Party. All 6 of the court's Republicans joined Calais, which repealed the 1982 amendment and imposed a new rule requiring voting rights plaintiffs challenging a gerrymandered map to show that state lawmakers acted with racist intent. This seems like a huge step backwards because, like, I know in criminal court, intent, state of mind when you're committing a crime does have a huge impact on, like, the kinds of charges that are brought forth and the types of penalties that might be incurred. But intent is also particularly difficult to prove. And when you're talking about something that's like super high stakes, like drawing of House of Representatives district maps in a given state, it would be almost impossible to prove intent. And it would be probably fairly easy for lawmakers to hide or obfuscate intent. It makes a tremendous amount of sense to me that, like, the rule would be based around, like, the effect of the redistricting, not so much the intent. But it seems like, obviously, they want that aspect removed. And they want it to be more like proving intent in a criminal court, I guess. I'm probably giving them way too much of the benefit of the doubt in this argument here. But, like, regardless of how you want to frame it, it seems like a step backwards, right? Because say you, like, throw a big rock off a cliff and that cliff hits somebody and they die. Your intent may not have been to hit anybody with that rock, right? You were just throwing the rock, right? So in that case, it would be manslaughter instead of murder. But, like, you still killed somebody, right? It's that person still, regardless, of if you were intending to kill that person by throwing that rock off the cliff or not, that person still died, and that's still a bad thing. And so, I don't know. This seems dumb. Seems very bad faith. I would think any good lawyer would understand the argument that you would want it to be based on effect, not on intent in this specific regard when it comes to gerrymandering. Under Calais, a plaintiff bringing such a challenge may only prevail when the circumstances give rise to a strong inference that intentional discrimination occurred. In the Allen case, however, a 3-judge panel that included 2 Trump-appointed judges determined that, quote, "We cannot understand Alabama's new congressional maps as anything other than an intentional effort to dilute Black Alabamians' voting strength." The panel reached that conclusion in an astonishingly thorough 571-page opinion handed down in 2023. Oh my God, that is an absolute novel. Would I rather have the trash truck or the recorder kid? I'd rather have the trash truck because at least I know when the trash truck's going to be gone. It's going to be gone in a minute or two. The recorder kid, I have no idea when he's going to tire himself out with that stupid screeching instrument. After Calais, the Supreme Court ordered that panel to reconsider its ruling, and the panel did not change its mind, concluding again that Alabama engaged in intentional race discrimination. Among other things, the panel pointed out that the 2023 Alabama law drawing the new maps achieved its racial goals by holding together a majority white area of the state known as the Gulf Coast, while dividing a Black majority region known as the Black Belt. Why do they get to call that the Black Belt, but the Gulf Coast is just the Gulf Coast? Like, why can't it be the White Coast? Huh? That'd be funnier. Incredibly, the 2023 state law said that the Gulf Coast shall be kept together to the fullest extent possible, in part because Alabama lawmakers wanted to preserve its distinct culture stemming from its French and Spanish colonial heritage. Damn, girl, they think they're being slick by saying that, but distinct culture stemming from its French and Spanish colonial heritage when you're talking about Alabama, which is one of the, like, blackest states in the whole country, right? There's no question about what they're doing. The state legislature, in other words, wrote into the statute itself that it wished to preserve a European American region of the state's ability to elect its preferred representative, while the same law also broke up an African American region of Alabama. If that doesn't give rise to a strong inference that intentional discrimination occurred, nothing does. Yeah, I don't know how that's not race-based, right? Like, would they argue that because they didn't say white or black, because they said French and Spanish colonial heritage, which is just white, that's how they tried to skirt the restrictions in the Civil Rights Act and the Voting Rights Act, right? That seems so, like, now it makes so much sense why they wanted to remove the effect part, the way that the Voting Rights Act was established, and leave it just up to intent, right? Because then it allows loopholes like this whole just calling it distinct culture stemming from its French and Spanish colonial heritage, which it's no question what they're talking about, right? It allows them to loophole their way into this being legal, which means so long as the legislature doesn't come out and says distinct culture stemming from its white European heritage, as long as they don't use that word white or black, then it's fine. The Republican justice's latest opinion in Allen, meanwhile, is only 4 pages long, and it spends only a single sentence responding to the hundreds of pages of evidence the lower court compiled, which shows that Alabama engaged in intentional race discrimination. According to the Republican justices, the lower court, quote, did not heed the presumption of legislative good faith. Oh my God. Really? Legislative good faith? Stop. That judges are supposed to apply to state lawmakers who are accused of race discrimination? No shot, bro. Come on. Presumption of legislative good faith. All right, so just jumping in here really quick. It seems especially problematic to combine the Calais ruling standard of when the circumstances give rise to a strong inference that intentional discrimination occurred with the Allen standard of a presumption of legislative good faith. The key word here is inference. How could one possibly make such an inference if a presumption of the opposite, that is, legislative good faith, is to be assumed? When these two standards are held simultaneously, the Allen case's presumption of legislative good faith acts as a shield of sorts for any inference of intentional discrimination. This legal dynamic is proven through this new Allen v. Milligan ruling, in which the lower court found, and upon appeal reaffirmed, the clear, strong inference of racial discrimination in Alabama's redistricting efforts. But like the whole concept of legislative good faith when it comes to elected representatives is just like an absolute freaking joke, dude. So to summarize, just over 1 month after the court's Republicans declared in Calais that racial gerrymandering plaintiffs could still prevail if they can show that a state's legislature engaged in intentional race discrimination, those same Republicans appear to have abandoned that rule. And the upshot is that the Republican Party gets an extra seat in the U.S. House. So this is sort of an acknowledgement by the Supreme Court that, like, okay, you could reasonably see the wording of that statute and the way that the redistricting law was written in Alabama, that it was race-based, but we're going to give them the presumption of good faith that that's not what they meant, right? Why is it a presumption of good faith that they wouldn't want to racially redraw it, right? Like, it's absolutely in their best interest to do so, right? As this article points out, it's going to give them an extra seat in the U.S. House. That is a clear political incentive, right? It's not even a good faith-based thing, right? If your party, it's just basic game theory. If your party has the ability to, pass a rule that gives you more control over the game, then clearly you're going to do it, right? Like, the GOP justices' Allen opinion isn't even consistent with their previous decisions in the same case. As Sotomayor explains in her dissent, there are several other examples of the Republican justices taking one position in previous decisions, then abandoning them in order to hand a victory to Alabama Republicans. This is like such a huge problem with the way that the Supreme Court is structured, right? There's no backstop. The Supreme Court doesn't even have to give legally coherent reasoning behind their decisions. And because there's no court above them to review their decisions and decide if they were correct or incorrect or biased or not, they can do whatever. They can essentially rule however they so choose in an explicitly partisan way with no backstop, right? In fact, I'm pretty sure that the Supreme Court doesn't even have to give any reasoning, right? It said they only gave a 4-page response to the 571-page reasoning gave by the lower court that it was in fact racially gerrymandered. They don't even have to give that 4-page report. They could literally just say, no, we're allowing it. No reason given. They do that. Apparently, they've been doing that more and more often recently. It seems like such a clear problem with the way the Supreme Court is structured. And to couple that with the lifetime appointments of the Supreme Court members, right? It just seems like a glaring problem that this isn't even a modern problem, right? I don't see how the founders of this country and the structure of governance didn't see this as a clear problem in the future. Or a potential problem in the future that needed to have some sort of backstop, right? And I know technically Congress can get together and void certain decisions that the Supreme Court makes by writing legislation, right? But in the way that Congress is set up in our two-party system, right, in the first past the post, winner takes all system, right, a whole half of the government is going to be inherently disincentivized from doing that kind of thing. It's an unrealistic way of dealing with the problem. The most galling in Calais, the Republican justices explicitly stated that we have not overruled Allen, a reference to the Supreme Court's 2023 ruling in this very same case. where the court struck down Alabama's maps and ordered it to draw new ones. It's now clear that the Republican justices were lying when they said that in Calais. The court's 2023 ruling in Allen held that Alabama must draw maps with at least 2 black congressional districts, while in 2026 ruling in Allen holds that Alabama does not need to do so after Calais. So Calais overruled the 2023 opinion in Allen. And this ability to be legally inconsistent seems like a clear problem and clear hurdle to potentially getting some very progressive legislation passed in the future, right? Let's imagine Congress gets their together and we get a House of Representatives, a Senate, and a president that's willing to pass some sort of like universal healthcare bill. I don't see any reason why, using judicial review, that the Supreme Court couldn't just come out and say like, no, we're going to reject it for these really, really bad reasons, right? And then the only way to overturn it would be, I'm pretty sure, like a 2/3 vote in both houses of Congress, right? Which is just never going to happen for anything. Sotomayor also spends much of her opinion warning that the court's latest Allen decision is likely to cause chaos in Alabama's upcoming congressional election, because the primaries in that election are supposed to take place on August 11th, leaving the state with very little time to complete the time-consuming task of going through each voter's record to make sure they are assigned to the correct district. Isn't like the reasoning they gave to not take up certain cases regarding Trump leading up to the 2020 election was that it was too close to the election and then it would influence things, right? They just seem to not be applying that same standard here for some reason. Not for some reason, right? It's very clear the reason is because they're political actors, right? They're activist judges. They are the exact thing that they accuse the liberal boogeyman of being, right? It's just pure projection. According to Sotomayor, after a federal district court first struck down an earlier version of Alabama's maps in 2022, the state told the Supreme Court that it needed to block that decision because the district court handed it down 4 months before a primary election, and 4 months was not enough time to change congressional maps. Yeah, exactly what I said, right? She's bringing up the exact point I just brought up, right? The fact that they then apparently even in another ruling, not regarding the Trump one, but regarding Alabama's attempt at redistricting in 2022, was struck down because it was too close to the election, right? So hilarious. Sotomayor's Republican colleagues appear to have agreed with that claim. Indeed, when the court agreed to block the 2022 decision, 2 justices warned that the lower court's order would require heroic efforts by state and local authorities in the next few weeks, and even heroic efforts likely would not be enough to avoid chaos and confusion. So when a lower court handed down a decision that would have benefited the Democratic Party by requiring Alabama to draw a map that would elect an additional black Democrat, the Republican justices appear to have concluded that 4 months wasn't enough time for Alabama to comply with that decision. Now, however, those same justices have decided that the state can pull off the same heroic efforts in just 2 months. So, oh my gosh, even I know about this and I'm not a lawyer, right? This is so hilariously inconsistent. Oh my gosh, they don't even care anymore. The mask is fully off. In fairness, the court's Republicans have occasionally ruled against their political party when the party presents particularly weak arguments. In 2020, for example, the Supreme Court famously rejected President Donald Trump's attempt to overturn his loss to former President Joe Biden. As I wrote at the time, handing a victory to Trump would have required Herculean efforts by the justices, because Biden won by a wide enough margin that the court would have needed to overturn the election results in 3 different states. That was too much even for this Supreme Court. Yeah, actually, that's such a good point. I wonder if that election was closer, if that election was much closer and it was only hinging on 1 state, then I think it's very possible that they would have tried to throw out the election results from one of the states or whatever. Right? They would have come up with some sort of screwy reasoning to hand the victory to Trump. But this is still the same Supreme Court which held in 2024 that Trump is allowed to use the powers of the presidency to commit crimes. Yeah, they gave him prosecutorial immunity for anything done while he's president, basically, right? Which means that he basically is a king, right? Which is sort of against what the founding fathers really wanted, right? They wanted the president to be not a king, right? That was the whole reason the country was founded and people came here. It was part of the reason was they were sick of monarchy-based rule in most of Europe at the time. And the Supreme Court in 2024 basically came out and said, yeah, no, more or less the president is a king and that he can't be prosecuted for crimes. He pretty much can go out and shoot somebody on Fifth Avenue, and that he's going to get away with it because as long as he gives the right reasoning as president. So the Republican justices are willing to do extraordinary favors for their political party and its leadership, even if they don't do the GOP's bidding in literally every case that comes before them. They have to give themselves some slight amount of reasonable doubt in the face of, like, I guess the legal world or the public or whatever, right? If they just explicitly and partisanly ruled literally every case in favor of Republicans against Democrats, right? They would have zero benefit of the doubt. I feel like the benefit of the doubt has to be gone at this point. I remember taking an intro to congressional law at university, and I just remember like the way that the professor would talk about like the way that the Supreme Court has reasoned different sort of precedents and arguments throughout the years compared to one another, right? I would love to see how he would talk about this kind of stuff right now. He has to see the Supreme Court makeup as like a complete joke, and the inconsistencies they're offering in their rulings just completely against everything that so many of the Supreme Court makeup stood for before this one. Yeah, none of this surprises me at all, right? Their legal inconsistency, they've just been shown to do that more and more lately. They've been handing down certain rulings without even giving a briefing at all. The fact that they only gave a 4-page reasoning to the 571-page opinion handed down by the lower court is an absolute joke. And yeah, the Supreme Court makeup currently, and it's so many of the Republican conservative-leaning judges in high federal courts and whatnot, are literally like the boogeyman that they try to pretend exists amongst liberal justices, right? They are the activist judges. They are the ones out there politicizing the court system and making judgments and rulings based on politics, and they're biased for one side or the other rather than the apolitical legal reasoning or rule of law. So many Supreme Court justices that came before these ones, I'm sure, would be absolutely disgusted with the way that the conservative-leaning Supreme Court justices engage right now. How they both with Clarence Thomas's like corruption with all the donations that he gets and the whole RV scandal, and also the legal inconsistencies with the rulings that they're giving down, right? Furthermore, I remember I did a story talking about like the NCAN standard and like how they've been biasing that towards Trump and that administration, right? Basically allowing him to use them as like a precedent-setting type of court without, going through their typical process of deciding what cases get to make it up to there or not. It doesn't surprise me at all, and seems very much from my non-lawyer perspective very legally inconsistent.